think we'll go straight, unless somebody has something right off the bat. We'll go. Somebody have a comment? Yes?
I'm very concerned about the weighing of interests, in particular environmental interests and other very valuable interests. And we got two interesting examples here. And the first one is concerning bankruptcy, because the claims I'm concerned about in bankruptcy are not the unsecured creditors by contract, but unsecured creditors in torts. For example, how do you weigh the interest of an environmental claim and a personal injury claim? I think it would be very unfair to prioritize environmental claims. And the other example is on insurance. There is today not possible to get environmental insurance in excess of about $1,000 million. Of course, it is possible to give laws about this, and that will cause some changes in the insurance market. But are we willing to take these changes, or should we perhaps research what kind of changes that would imply? Would people be willing to pay more for their home insurance, car insurance, in order to attract more underwriters to the insurance market? So my point is simply weighing of interests.
Good. Any other? We'll go to anybody with questions. Yes.
This is a question to Mark. I understand that the human rights due diligence tests are very similar to human rights impact assessments, which you didn't mention, and I thought those were problematic because they essentially perpetuate the idea that companies themselves get to decide, how far they have exercised due diligence or tested their human rights impact, that there's no outside monitors, that there's very little engagement with stakeholders, which this morning we were seeing as something being quite important. And therefore, it does seem a rather weak model to ensure that either environmental or human rights concerns are met.
Sure.
Do you think? What do you think? Sorry to that question.
I think it's a misunderstanding of what I presented, because human rights impact assessments are internal processes in the company. What's being suggested here is a standard in law that would be the standard against which you assess whether or not the company has respected human rights. It's important that and then the question is the various mechanisms that is actually brought into. Is actually adjudicated, whether it's through disclosure mechanisms or whether it's through a civil action or criminal court. So the standard is not due diligence. The standard is respect for human rights. Due diligence is the means by which you do that. So I would not absolutely ever advocate that a human rights impact assessment would be definitive evidence of company respecting human rights. Quite the opposite. It would be evidence that the company would have to present as to whether it did or did not in a particular situation. Do you get my point?
Legal mechanism to be overseeing.
Absolutely.
The kind of role that they take. Okay.
Absolutely. In a corruption case, for example, there is a bribe that is paid. And the company has to show that it conducted in order to avoid liability, the company has to show that it conducted due diligence and it took steps to ensure that didn't happen, that didn't happen. And that's a similar model in which this kind of due diligence would operate. Similarly, in labor law, yeah? One of the effects of due diligence, by the way, is actually to get through that separate entity doctrine, so that you're required to respect a standard in law that is not, it brings responsibility across the separate entities in a way, so that a contractor who has responsibility for a project where there's multiple subcontractors working on a particular site is also responsible, as well as the particular subcontractor that might cause the direct harm. Yeah? So if I, for my organization, pay a bribe, I'm responsible under the law for doing so. It may also be that the company I work for is responsible. And the company has to have a system in place to ensure that I don't pay that bribe, and that system in place is also the evidence it would present in a court of law to show that it couldn't be held liable.
Andrew?
Okay, I'm going to have to follow you up on
Yeah.
that, I think. Otherwise,
I just had an idea for all the people who were talking about clearing up the mess that was left after a company had done its thing. And what about the possibility of, when the company's setting up its operation, the state requiring it to make a deposit with the state of the likely costs of the clear-up, so you have some kind of estimation of how it would be. Essentially, this would be a requirement of over-capitalizing the firm over and beyond its current level of capitalization. Shareholders might have to double their capital investment. That would kind of get around some of the problems that I think you were talking about with insurance, but obviously raises other issues. I just wonder what you all think about that.
Erik, was that a response to Andrew?
Yes,
Okay.
we were probably going to say the same thing. This has been tried and is used very much in shipping, with mandatory insurance for pollution claims. And in shipping, the problem is not only the conglomerate of companies, but also that they are inaccessible. So actually, we do not care very much about the companies, the owners. We care about the insurance, go directly on the insurance.
And also in Sweden, for example, I write about it in my paper, in the permit process, there is a possibility to demand that there is mandatory insurance or other financial securities. And also, if we look at the Swedish preparatory work, for example, for the environmental code, there is a specific purpose with the permits. And the permits are supposed to be an instrument towards sustainable development. So when you use the permits, you should use them in a way that supports environmental protection and so forth. So you actually have an instrument already there. And the directive on extractive waste demands that there is an appropriate financial security. And appropriate financial security means that it has to be protected in the case of insolvency, for example. So there is a system that could be used even more applied towards sustainable development.
If I may add just one little thing there, and that's in the North Sea for oil companies, there is a requirement for financial security. The oil companies prefer to use insurance. Why? Because they use captives, and then they get all the profits out of the Norwegian tax zone with 80% tax. So there are many traps here.
If I can just add to that, sorry. I'd be quite happy adopting that suggestion as long as it was money that was genuinely being set aside. I think as a company law scholar, you know that with something like minimum capital, it still gets used up in the course of the company's business. So you wouldn't want something that creates a false sense of security. Also, I think in the UK context particularly, we would need something that covers a range of business models. So something like landfill operation attracts a lot of sole traders. You wouldn't want to feel that certain forms of business were being targeted at the expense of others.
In the loop, and then we go to the audience.
There are discussion about this option in China as well, but was given up for two reasons. One is there will certainly increase the burden of those people who start their business. And secondly, we already have a general, what we call the polluting fees paid by companies in those polluting industries. And that money will be used for environmental protection generally by the government. I actually had learned from Professor Henderson yesterday that in Canada, if you do a mining business, you will have to pay something like bonds or ordinary money in the very beginning. And when we discussed that idea, I mean, not with Hansen, but with my colleagues in China, the reason we don't like the idea is because if you pay that bonds or honest money, you actually cannot use the money, until at the end of the day, it turned out that the end prices fail to do everything in accordance with the law, and there's pollution, there's damage, so therefore the money will be taken by the government. So during the 10 years or 5 years time, I mean, you could obviously invest the money, but taking care of the money is also kind of burdensome things. And given that the amount of money will be huge, I mean, just think about that.
Christina.
It's a slightly different question, but many companies don't just operate in one country. I mean, they operate in many different jurisdictions. And it appears to me, I only listened to this conference today, I couldn't come here yesterday, but it appears to me that sort of this multi-jurisdictional aspect is not really being addressed, that companies may have to relate to different countries' laws and jurisdictions. And in this context, I have a question to Mark. I find your presentation and the proposal and very intriguing, very interesting, but I just wonder how it relates to claims of extraterritoriality, where you have a parent company in whatever, Brussels, and then you have subsidiaries with own legal personality in Sudan and whatever in the world. And the question is, how can you really extend human rights obligation and due diligence to all these subsidiaries all over the world? And the final question, would you also be prepared to conduct a similar study on environmental issues?
Sure, if there's the funding, absolutely. Yeah, it's a very good question. It was really central in the debates in the human rights arena. I guess I would answer in two ways. One is the sort of practical legal one, which is related to what I said earlier. By getting at the responsibility for the business to respect through its business relationships, at the level of the international norms at presently, that applies to all of its operations globally. And one of the things that this French proposal does is specifically leverage that within the French legal context. And so to adjust the civil and penal code to extend extraterritorial reach, or I should say effect, of domestic rules. So in other words, you don't actually reach, but you regulate domestically activities and relationships, decisions, and so on that are made within your jurisdiction that have extraterritorial effect through your business relationships. The obvious examples here are things like supply chain management, but it would also apply to security management that is conducted within your jurisdiction that has an effect in a foreign direct investment abroad, for example. So that's one way. The other way is more at the policy level, which is that it is increasingly, because there is increasing coherence with the norms in the guiding principles, the OECD guidelines in EU and so on, even though it is relatively early days, this notion of business responsibility to respect human rights, of the due diligence as the operationalization of that, it is beginning to look as though there is the basis for policy coordination around these issues. And so what you're starting at the international level. And so what you're getting now is the beginning of a push amongst civil society organizations, but also certain governments for international instruments to help create that playing field with respect to extraterritorial jurisdiction in particular. So Ecuador, on the back of its experience with the case involving Chevron and Texaco, has put forward at the Human Rights Council a proposal to do exactly that at the international level, to apply international legal norms to multinational entities. Now, the likelihood of that succeeding at the Council is very slim, but I think that the policy coherence on first principles with respect to the nature of business responsibilities for human rights is what's helping to encourage that international policy coordination.
What started as voluntary standards is now moving into the realm of more requirements.
Somebody said earlier today, or maybe 2 or 3 people said over the course of the 2 days, that almost it's an assumption that we are sort of in a new era of CSR. I would not be so, I don't know whether that's a pessimistic statement or an optimistic statement. It depends on your view of CSR. But I would not be so optimistic that we are, there's a kind of linear progress towards increasing accountability. But my view is definitely we are at a moment at which that is quite possible. And what the French proposal does is recognize that in the guiding principles, there are notions of responsibility, namely acts and relationships, that are perfectly analogous to criminal and civil notions of responsibility.
Priscilla?
My question is to Johanna. Thanks for your presentation. I kind of like your concept, but I just need some clarification. You're seeking to use the polluter-pays principle in relation to the liability directive. I'm not sure because the way the EU is going on about the polluter principle in all, including its case law, I see it's more of a regulatory incentive instrument that allows states to sort of like implement certain regulatory framework for ensuring that, and that the liability directive sort of does not undercut fault. So how do you reconcile the fault regime? Because, I mean, the whole point of the polluter pays principle is to ensure that companies are accountable, fault or no fault basis to improve.
For the Annex 3, which are the harmful or potentially harmful, there is not an issue of fault because the liability is strict. Then for other operators, it's fault-based, and of course it is an issue to really show fault. But for these operational activities, the liability is strict, and that makes it quite much easier to address. Yeah. Sorry, I didn't hear. Yes, well, insurance in itself holds functions and principles that would be possible to use in a way that supports sustainable development and supports that environmental damage is actually handled adequately.
We have to draw the line, or else we have no coffee break.
Okay.
Sorry. We'll take it to continue the discussion in the break. All right?
Mm-hmm.
Okay. Thank you very much. And then we'll